So things you threaten management, hurt another tenant. There's 19 reasons to evict someone. None of them are your lease is over, by the way, but you have, unless it's commercial. But these are for cause when someone does something really bad. It has to be really bad because we're in a pandemic and the court doesn't really care for most things. You're destroying the property, but it has to be real destruction, not just like, you know, broke all the doorknobs off and broke the windows. It has to be more than that. It depends on the judge too. And that's another amusing thing. Each judge does it differently. So we never know what we're going to get when we go to court. So we've been going into what's called mandatory management conferences. So I put that in quotes, not to be obnoxious, but it's mandatory for the landlord, not the tenant. So if they don't show up, then in 2 to 3 weeks, it's scheduled for a trial. At the mandatory management conference, we have a whole lot of things we have to do. Actually, we now have to do them ahead of time. There's new requirements. The new requirements are we need to know if there's federal financing, if you've got financing through federally insured. We need to know if you've got rent control. I generally know that anyway. We need to know, you need to see your lease and give them your lease. And the most important thing now, and I find this very amusing, is we have to make sure you're a registered landlord. Now, being a registered landlord does not mean you have a CO. It means you've either registered with the town as a landlord or registered with the county if you've got more than 2 units in a building. So all these people who always told me they were registered, now that push comes to shove and I have to send the registration to the town and we have to upload all this stuff. And we have to do a CIS statement when we do evictions now. When I do that, I find out, they go, what's a registration? Now they've always told me in writing, yes, we're registered. Well, they're not. So we have to send that to the town or they will, or to the county, or they won't cure our evictions. So those are all new things we have to do. And then instead of having 1 hearing, we have 2, maybe more. So the first hearing we have is, like I said, this management conference. At the end of the management conference, if the tenant shows up, this is like a flow chart. If the tenant shows up at the end of the management conference, then we mediate. If the tenant doesn't show up, we go to trial. What happens when we go to trial? We have to mediate. We can't tell the judge, oh, I don't want to mediate. These, you know, tenants are deadbeats. They don't care. Yes.
I have a question. Landlord registration. Do you mean when you fill out the form and send the check? Or is the landlord registration when they did the inspection, you did the repairs and you got
No,
your
that's a CO.
compliance?
So
Now, landlord, like when we submit a landlord registration, it's a check and an application. And then the township will do an inspection in some towns, annual inspection, and then they, every year, they give us that we're in compliance.
okay, that's
So
what
when you're asking for a landlord registration, you just want to see we filled out the application and paid the fee?
the towns have a registration form.
Yeah.
Normally it's your name, your address, your emergency contact,
Mhm.
and who's,
Right.
you know, that information. Now, one little thing, it also asks you who your mortgage is with. Don't ever fill that out.
Oh. No.
Why?
Okay.
I always do.
Now,
Yeah, I do too.
why? Because most of your mortgage application, your mortgage notes and mortgages say if you're in default. So if you're doing, the mortgage company can take over. So you could have tenants going and filing a complaint with your mortgage company. So they can go around and they can tell your mortgage company, hey, you need to fix this. And you're like, well, you broke it. And then your mortgage company could call your loan and say you're in default. Right now, they're not likely to do that. But guess what? When rates go up, they will. So these tenants are very smart. And they're going to get online, they're going to find out who your mortgage company is. So I always leave that like,
Okay.
it's none of those.
You got a mortgage person.
Sorry. I'm not saying, I'm just saying,
He's kidding.
no, but I know, but it's an important point. I'm not saying anything, you're not doing anything wrong. But you don't want the tenants telling your mortgage company, because then they'll call them and I mean, you should hear the things they say that are so untrue. And then your mortgage company's going to say you're in default.
So you just write in that space refuse?
No, you say none,
None? Okay.
or leave it blank preferably. Because you don't want to tell them.
Greenberg's got, nobody has a mortgage.
Good. I'm just telling you, because I know it's happened.
Yeah. Okay,
Tenants
good.
can go, they can get a copy of registration, they can contact your mortgage company, and then they can complain to your mortgage company again. And most mortgages say that the mortgage company can come into your property and fix anything the tenant complained about. And you don't want to be in that position where they can call you in default.
Right.
So then the next step is we go to landlord tenant, we go to trial, the tenant doesn't show up. And then if we go to trial, once again, we have to have this mediation. If the tenant doesn't show up, then it depends on the court. We may either put a proof hearing in that day or just file certifications, and then we can get a lockout. So we're able to get lockouts. Now, the other thing that was really interesting, these are all the happy things. I'm about to tell you some things that aren't so happy. The other thing that was really, really interesting was that if you have a warrant from, I call it the before times, you have a warrant from before March 1st, 2020, and the courts didn't execute it. What do you have to do? Well, September 17th, the Supreme Court of New Jersey said, all you have to do is send a letter to the court, and they're going to reinstitute all of those warrants and do those lockouts. So we've been doing it. You don't have to file a motion, you don't have to do anything. It's like one time only, has to be done by December 30th. You can go in and all those old warrants, we can get people out, and we are.
Okay.
Now, those were all really happy things, weren't they? The forms have all changed. So what happens now and the forms have changed for settlements too. This gets really technical. It's a settlement where you've entered a judgment for possession. I want to give you what that means so that you know, because a lot of people don't understand. A judgment for possession, and this is going to tie into the bad news I have, says that the case is pretty much over. And then if the tenant doesn't comply, you can go for a warrant of removal. You don't have to do anything further other than say there's a breach. Okay, that's great. But the new forms say, separate it out, that you don't always get a judgment for possession. They're trying to encourage tenants not to get a judgment for possession. So why do I care? Two reasons. One reason is if they file and I get a judgment of possession, they can't go bankrupt on me. That's big. The other reason is we're about to talk about, and I called it hiccups. What are the hiccups? And they're big. If the tenant has an eviction that's been filed for COVID period rent. COVID period rent is March 1st to August 31st. And remember, these things change every day. I had 5 rule changes in a 6-day period recently. Right now, the covered period is March 1st, 2020 to August 31st, 2021. It's a little glitchy, I'm not exactly, but that's basically what it is. If they file a certification saying that number one, they've been affected by COVID, and who in this room has not been affected by COVID? Affected by COVID means your costs have gone up. Well, all of our costs have gone up. And you're below a certain income level. And that income level is basically 80% of the average income level, which most tenants are, because if they're making more than 80%, they're going to go out and buy a house. Well, not now because the market's crazy, but if they're below 80% of the income level and they've got the certification and they do the certification, their eviction gets dismissed and it becomes civil debt. What does that mean? Well, they changed the numbers on what you can apply for civil debt. If it's under $9,000, you can apply for it yourself. If it's over $9,000, there's a high level, I think it's 45,000, special civil part, it's no longer 15. You can go and you can file through an attorney for, if you're a person, not an LLC, you can file any wet time, but if you're a corporate entity, you can't. If it's above $9,000, you have to file through an attorney. You were not allowed to sell that debt. So basically, they filed and it becomes civil debt. Good luck. The other part of it, though, is that what about September 1st, which we're now past, right? So, and they haven't done this yet, thank God. If it's from September 1st on till the end of the year, right now, if Governor Murphy gets reelected, I'm sure he'll extend it. I'm not going to comment. Then you can still file. And if they owe that rent, you can undo their certification. Doesn't undo the civil debt, but it means you can still proceed. One of the things I've told people all along is we don't want to lose our place in line. File, 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 file. So now, should we just file a new one? Or should we file a motion to reinstate? Motion to reinstate. I don't want to lose that. I don't want to lose my place in line. So if you've got rent due from before March 2020 or after August 31st, undo it. Now, what happens next?
What do you mean by undo?
Well, we have to file a motion to say, hey, you shouldn't have dismissed this case. Now, the United States Supreme Court, which I don't think New Jersey follows, says that you cannot, this is a New York case, but it was for the United States Supreme Court, you cannot dismiss a case solely based on the tenant's certification, but you can in New Jersey. So that's bad, but we can undo it. And then what's the process there? So we file a motion saying, hey, they still owe rent. They owe rent from the non-covered period. This is also, they owe for cause, put me back. Now, some counties or judges say, okay, write me a letter, I'll take care of it. Other judges make us file a motion. Then they reinstate it and we're back in line where we were. But we still have the civil debt issue. Here's where the next one is, and this doesn't make sense why they didn't do this for this period. If you want the second set of money, if you want to get relief there, you don't get the relief, but you get time. You have to apply for aid and you have to comply. The tenants do. The tenants have to comply, they have to apply for aid. And a lot of them don't bother. So if they do that, then you can't lock them out until January 2022. All this stuff you heard about CARES and all that stuff, the Supreme Court of the United States said, no, you can't do that. You know, when they passed some stupid, some directive saying that you couldn't have, you couldn't do an eviction, the CDC passed that and after President Biden said, we know it's illegal, but we're gonna do it anyway. And the Supreme Court said, So that's gone. The CDC has not stopped our evictions, but New Jersey has. So, but if the tenants don't file these certifications, and God, you know, most of them don't. I don't know how many evictions I have outstanding, a lot. I've gotten 11 certifications. They're not filing them. And I'm glad about that.
Everyone of mine have filed.
Okay,
And so the certification, is that the DCA application?
it's not the application, it's the certification, that's different. The DCA
What is
application.
the difference?
Well, the tenant files a certification with the court saying, you know, I've done this. Filing DCA,
They're just certifying that
they're
applied.
poor and that they've been affected by COVID. And then their case is dismissed and then we have to reinstate it. Now, at that point, please excuse my voice. At that point, it's always best to talk to the tenant and say, hey, because you brought up a really good point. File your application, get your rent paid. This way, this isn't going to be hanging over you as a civil debt. You know, most of the time they're not working or they're working, whatever they're doing under the table. But at some point, that debt's going to show up if they ever want to buy a house, sell a house, that debt's there. So you really want to work with your tenants. Now, this is the question everyone asks me. Can I apply on behalf of the tenant? The answer is yes, you can, but they still have to cooperate. And that's the point. It's a sales job. Get them to want to cooperate, yes.
Lori, how's that debt going to affect them? Because as pursuant to the federal government, they've told landlords you can't file that they haven't paid from 2020, from March 2020 until September 1st.
Oh, it's September 1st. It's October.
You know what I'm saying? So what's the point? You know they're ahead of the game.
They're ahead of the game, but they
No one's
can't.
going to file, and it's not going to be negative towards your credit. It's not going to be negative towards your purchase power with the mortgage company.
It is now, it's September. We're outside the covered period, you're right.
But you can't go backwards. Can you retrospectively say, hey, listen, you haven't paid me since March 2020? No, you have to forgive that.
You don't have to forgive it, you can file civil debt. But the thing is, and this is how it's working,
I hope so.
if they're staying there, then they can't continue to stay there unless they continue to pay you rent. So let's just take the person who hasn't paid. Excuse me?
Good luck finding a new rental. In this market, it's just really hard.
Right, well, I mean, here's the bottom line. If you've got, because you're not supposed to consider the fact that they haven't paid rent for the past 18 months, but you've got somebody who's working and you've got somebody who's not, who's gonna get the rental? You know, you're not gonna say, oh, well, there was an eviction, blah, blah, but you are gonna be able to tell easily whether they're a decent rental or not. And if people weren't paying rent, you know, you're not gonna bring them in. But money's flowing in. I got people getting $20,000, $30,000. Money is flowing in, which is really stinky, because those of us who paid all of our bills and paid our rent and did all the right things, okay, but what about all those other people who just didn't pay? And now, you know, I mean, I've got one tenant, I always do like one tenant a year to make up for the bad things I do the rest of the year. And they raised their rent 40%. I said, stop paying and apply for aid. There's nothing they can do. But why should anyone pay rent? The DCA is pouring money out. There's still plenty of money available. But what's amazing is the fact that people aren't applying for it. So you as, you know, property managers, realtors, want to get in there and you want to say to that person, look, you don't want this debt staying on top of you forever, because it will. Because we're going to file a complaint against you. We're going to get judgment. If you ever go to buy anything or sell anything, this is going to pop up. Let's apply with the DCA and help them, because a lot of people don't have the ability. They just, it's overwhelming. The application's overwhelming. I looked at it. It's overwhelming. So you want to be there and help them. Now I have some that are like really disgusting and they say, well, I'm not going to do this for you unless you give me some of that money. Don't do it. Just say, fine, I'm going to evict you. Because then they're not paying September either.
The free roof over their head wasn't good enough.
Yeah, they want to kick back. Now, there's all kinds of interesting issues about the DCA, and I have a whole bunch of questions, you know, landlord questions. But I think that the thing that came up when we talked about judgment for possession is once we have that judgment for possession, then they can't file that certification on you. So a lot of times we enter into crappiest deals imaginable, just so that we can get that judgment for possession. And if we can get that before we go to court, we don't have to enter it in front of a judge. So if I have someone, they owe $20,000, and my typical thing will be, okay, you pay your rent on the 1st, and on the 15th, you're gonna pay something towards the balance. And by December 31st, you're gonna pay the balance off. And I got a judgment for possession. I know they're not gonna pay that rent. I know it, but guess what? I can now evict them, and they can't file the certification. I mean, it depends on the judges. They're not supposed to be able to file the certification because we have an agreement. So once we do that, then we have an agreement, and then they can't file a certification, and I can do a breach. Yes.
And well, the person that I had sent to you that has that tenant that keeps filing bankruptcies. Does this take care of?
If you have a judgment of
situation like
possession,
that?
it takes care of the bankruptcy, but you can only file bankruptcy a certain number of times, it becomes fraud. So I don't remember how many times they filed within 2 years, but it does become fraud. But yeah, they keep filing bankruptcy. So the game they play is one files bankruptcy, then the other files bankruptcy.
So what happens after September 1st?
Yes,
They can't file a certification any longer?
they can, but it doesn't stop the eviction. It doesn't become civil debt. We are afraid that when Governor Murphy wins, that he will make it civil debt, or they're going to change that. But right now, it doesn't. So right now, you can't lock them out until January if they file that certification. But they also have to have applied. And if they apply, they're going to get money. The money's there.
Yeah.
So
So they get the money, so let's say that they owe $30,000 in back rent, and you get 20,
right,
the landlord gets 20. What happens to the other 10?
civil debt, you can still sue them.
You can sue. But now, September 1st comes and they're still not paying their rent. You refile for the eviction?
Well, remember, it depends if I reopened it or if I refiled it.
Okay,
If I reopen it, I'm already in.
okay, good.
If I have to refile, then yes. Now, I held off all my evictions in August when I found out about this till September, so that those evictions wouldn't get dismissed. And I'd have September rents, so that way they can't dismiss it, because they will. Now, there's some legal services people who say that even if you have an agreement, that certification undoes it. I was just with Judge Harrington and the top judge in New Jersey, and they both said, no, it doesn't. Once the agreement's signed, the case is done. And that certification will not undo that agreement. That's what they said. Does that mean that's what's gonna happen? Who knows? We already have a problem in Cumberland where we had a no-show. And they said, oh, you can only include non-covered COVID rent. I was like, but they didn't follow certification. And the judge said, too bad. We got them locked out anyway, because they didn't pay the non-covered time period. So the other things we have to talk about is, let's see what we have under hiccups. There's lots of funding available, and I gave you some resource information in the handout that you have. And there's NJ 211, there's like 911, it's NJ 211, which has a list, but a really great source of information is the Apartment Association, NJAA. And they have a great list of where funding is available by county. Now, here's an important point, and I run into this. You cannot refuse to accept DCA money or Section 8 money. That is a civil rights violation. The tenants could file a HUD violation. So you've got a notice to quit. The person's exposing himself to little girls or boys. Not that that matters, but it's a disgusting thing to do. And believe me, I had that case. And the money comes in. Do you have to take it? The answer is yes. So the question is, does that undo our notice to quit? My position is that it doesn't, because you're required to take it. You have no choice. You have to take the money. We've discussed it with judges. We don't know what they're going to do. Some legal services people, if they got the case, said they're going to claim that since you took the money, that undoes your notice to quit. I'm going to make the argument that it wasn't a voluntary taking of the money. It's the same thing as Section 8. Section 8 gives you money and they deposit it in your account. But that doesn't mean you violated a notice to quit by taking Section 8 money, because it's a crime not to take the Section 8 money. So you don't have a right to do that. Now, security deposits. This comes up all the time. The people can no longer use their security deposit to pay their rent. However, the people who did use their security deposit to pay their rent had 6 months after the date of their lease ended, or now it's December 1st, 2021, whichever is less, whichever is more, sorry, whichever is more. So most of the time it's going to be December 1st, 2021. You know, tenants were allowed to use their security deposit to pay their rent. So after December 1st, 2021, you can demand that security deposit back.
And what happens if they don't pay it?
Evict them.
Okay.
Normally you enter into an agreement and give them time to pay it back, and enter into like a payment agreement, you know, something a month.
So they
towards the-
literally have to replenish their security deposit.
Yes.
account.
Governor
After December 1st.
Governor Murphy was sued for that law, and that person lost. Yes.
Go ahead. Yeah.
The general lease calls for specifically, you can't use the security deposit for rent.
There was an executive order that said that you could use the security deposit for rent. I don't remember what order it was, but it said that you could, and it was ended September 4th, I'm not sure. So when the state of emergency ended, you had 6 months after that to pay back the security deposit. So they did let people do that, but now they can't. That's over. They can't do it.
And that's the 9/1 date you're talking about.
12/1.
That's when it's due, but it started.
When did it end?
Yeah, it ended 8/31.
No, it ended, was it June 4th, July 4th?
That's why they have till December.
That's why they have till December, 6 months.
All right, I got you.
So then they have to pay that back. So, you know, you reach out to people and talk to them about how they're gonna pay it back. Hey, you know, you're gonna have to pay this back. Let's work out a payment plan so you can replenish your security deposit.
And they can use the entire security deposit, which is usually like a month and a half.
Yes, but they can't anymore
No, when they could.
when they did. So they can't come to you and say they want to now.
No.
I think the last time they could do it was August 4th, but since then they haven't been able to do it. And December 1st, they have to pay you back. So, but that means, and I mean, things look better. 2 weeks ago, I wouldn't have said this, but I watch the numbers every day and the COVID numbers are going down. So things are looking better. It looks like Delta's moved through. So we'll see. We'll see what's going to happen with that. I don't think that that's going to be a problem. I think that, I don't know. The governor's going to want to do all kinds of things, yes.
It seems like a lot of talk about deadbeat tenants. What about people who honestly were affected by COVID and lost their jobs because, I don't know, the restaurant that they worked for closed down? What happens to those people?
They're going to get DCA money. There's so much money out there, about $1.2 billion and more is still allocated. There's so much money out there. So there's 1.2 billion in the DCA and then each county has its own money. I mean.
Just that they don't know, a lot of them, how to fill out the paperwork.
Right, and that's what our job is to sit and help them as landlords, or, to sit and help them. Here, yeah, there's a million jobs out there. But
For all the tenants that we have that haven't paid their rent, we only had one that was a legit, really lost their job. She was a dancer, made good money, and the club shut down. And I know this is a faux pas, but her church helped her pay her rent. But she came in the office, she was very grateful for the DCA application we did. And then she got caught up and went back to work and we're good. But that was one out of about 20 of them.
and I've seen a lot more than that. And the other side of it is, I'm gonna be, you're not supposed to say these things anymore, but if you're a working mom and your kids were out of school, or a working dad, or a working person, and your kids were out of school, how are you gonna make sure those kids, were getting an education? You pretty much had to give up your job. And those were real. Those were real problems. And most of the time you as landlords want to work with them and do anything you can. But I've seen so many people who that wasn't the case. That would be the case so little of the time. Most of it was just people taking advantage of the system and not wanting to pay their
So
rent.
when we're getting the DCA money, we're getting something like 14 months of back rent and 3 moving forward. So it covers them for the back rent and then gives them 3 months to get a job. So they really can get back on their feet if they want to, but most of them are just right.
Now, when you get the DCA money, you have to waive late fees for that time period. And you also have to apply it like they applied it. So if you had rent due from 2019, you can't apply your DCA money back. You have to apply it like they tell it. Then this is a question I get a lot. What happens if they move out and I've got this extra DCA money? So the tenants go, well, I want it. I go, no. Landlord can't keep it, tenant can't keep it, has to go back to the DCA. Now, I gave you a list of frequently asked questions, but
And what's it's the landlord's responsibility to return it.
oh yeah,
Okay.
now how are they gonna track that? I don't know.
Let's check on that.
But, some of the people don't apply because they say, well, leave it. So if your tenant's leaving and you enter an agreement to vacate, then you can't take the DCA money because the DCA money is so that they can stay.
So for the most part, the DCA money that we're receiving is for back rent, so that's good to go. The moving forward money. So if we're getting 3 months to pay rent forward.
Yeah.
And they leave in month 1, we gotta return the other 2 months.
Yes, and the
it's
tenants
back rent, it's back rent only during the COVID period.
and future rent for months, future rent.
Correct. With that question about that civil debt, was anything like wage garnishments attached to that, or how do you go
Well,
about
you can
collecting
do,
that?
you can do that, you just can't sell it. So you can go to court, go get your, we don't like to do it, like the only thing my office will do is we'll file the complaint, hopefully they'll pay you, and then we'll file a judgment with Trenton. I'm not gonna go chasing wage executions, because they just keep flipping jobs when they get wage executions. It's just bad, clients hate me when I do that, I hate doing collection work. I only do it under certain circumstances when the client clearly understands what a mess this is. But I am sure there's gonna be law firms and collection agencies coming through New Jersey, helping people with this, who will do it as a percentage. So, you know, I really always try to dissuade people from going to me to do collection, because I'm geared up to do landlord tenant, not geared up to do collection, and it's awful. And I've done collection, and they change jobs, they declare bankruptcy, and all your clients say, why did I pay you for this? So go somewhere else and complain to them. I know I've got like people on, is there anybody here who wants to ask any questions?
Anybody on the Zoom call that has any questions?
Did you see any like chats?
Oh, there you go.
No, too depressed? No, hey, don't be depressed. We're getting people evicted. You know, it's working.
Alana, did you have a question? You're back on mute.
Or, I guess, pet deposits. So, it was explained to me that they can only take a month and a half rent total as a security deposit, and they can't take an additional pet deposit.
No, I can't.
And can they do, the new one I got was a pet application fee.
No, but what you can do is, and this depends on if you have rent control or not. I never introduced myself to all of you. Hi, I'm Lori Greenberg. I represent over, I don't know, 900 landlords. And I'm involved in this all the time. I'm on legislative committees. I've been doing this 35 years, involved in a lot of what's going on. So if you don't, and I'm involved in rent control too. If you don't have rent control, you can charge a pet fee. So the best way around that pet deposit is to charge them a $25 pet fee. With that being said, you can't do it if it's an emotional support animal or if it's a service animal. And please understand, I have nothing against people who are blind or deaf or diabetes and have that support service animal. That's an important animal. The emotional support animal most of the times is BS. And they go online, even like, I've had 40 service pit bull trials. I've won every one of them, where the person comes and says, this pit bull is my service pit bull. You go, you're out of your mind, you know, and then they let their
Depends on
service.
what business they're in.
Yeah, exactly, for their service drugs they're selling. And they let the service pit bull run without a leash. You can charge a pet fee. You can't charge an extra deposit. Now, the other interesting thing, and this is interesting in the industry, is some people have charged, instead of a security deposit, they're charging insurance. So they have the tenant pay $199 or whatever for insurance, and they don't pay a security deposit. The landlord keeps it, and that covers any damage caused by the animal or anything else. There is insurance out there. You might want to talk to Greg because they offer that to him. And that's like a hybrid. And they don't get that money back, but they're buying insurance for their
You
security.
can't say no, and you know it's BS. And the pet's gonna come in and destroy the house. So this pet insurance, you pay it to the landlord, you call it that, he has to buy the insurance?
Yeah,
Insurance policy, is it a real policy?
yeah, it's a real policy.
Yeah.
Tenants.
And is it called pet insurance?
No, it's called tenant insurance and it covers pet damage.
You
But
mean renters insurance?
yeah, no, renter's insurance is what, so when you go in, instead of getting a security deposit, you give a non-refundable non-refundable insurance. It's like my son was $199. We didn't do that. And because he doesn't have a pet, and hopefully he won't destroy the apartment. And you don't get that money back, but it covers any of the damages to the landlord, including pet.
And
damages.
do they have to take that money and buy an insurance plan with it, or can they set up their own?
No, the landlord does it. If they buy the policy, they have to actually sell a policy. They can't say non-refundable.
Right,
But
okay.
It's
So
a,
you call the real insurance company and you buy pet insurance with this extra
yeah, you want
Is
to,
it $199?
the one he had was $199. I don't know. I'll look into that for you.
12.
It's for 12 months. No, it was for the term of the lease.
And
It's like instead of paying,
$200?
what?
And it was only $200?
Yeah. Because they get it back and they never, you know, so most of the people don't destroy their apartment.
So it's called non-refundable.
Insurance for the security deposit.
Pet insurance.
It's not rental, it's non-refundable insurance for it, but there's all kinds of rules on that. And I'll get back to you on that. It's a real complicated issue, yes.
Did you charge a monthly fee?
Yes,
Okay,
but not if it's an emotional support dog,
okay.
or an emotional or a service animal.
But anybody can go to the web and say, my pet is an emotional support.
And you can turn
pay
them down for that.
$100.
You can turn them down for that. It has to be, they have to actually have a doctor from New Jersey.
Okay.
They
yeah.
can't come with a fake thing from the internet. The courts don't like it. Judges don't like it. Judges don't like pit bulls. If anyone here likes pit bulls, I'm very sorry. Judges don't like pit bulls. Judges don't like, BS from the internet saying that, this is an emotional support dog. One of my close friends said, my dog is a service dog, and the airline wouldn't let him on. I said, well, why not? They said, because they want to know where he was trained. He's a diabetic dog. I said, okay, who trained him? He said, I did.
Oh, man.
This is candy.
Yeah.
I am not going to help
I'm
you.
not
with that.
allowed to eat this.
Yes.
If Brian goes for pizza.
So it's sugar certificate, they would
If
present.
it's an
There's
online, it's
also-
not valid.
Well, so I guess I would have to know the difference then, but there should also be a doctor's note.
This is when with the service animal, you have to find out where it was trained, what it was trained for. With an emotional support animal, you have to have a letter from the doctor, and what I ask for is two things, or maybe three. I want a letter from the doctor saying that the person needs it. I want a letter from the veterinarian saying that dog is not dangerous. And I want insurance on the dog, special insurance. Now, am I gonna do that to a service dog? No, if it's a real one.
Right.
If someone's blind, they're deaf, whatever, we know what those people are.
Special insurance.
No, there's pet insurance.
No, I have pet insurance, but.
And there's insurance for that dog, because what happens is the people don't have the insurance and the dog bites a neighbor and now you're liable.
So
So,
they should have both, even if it is a support dog.
Yeah.
Legitimate support.
they should have insurance.
And what kind of insurance should that dog have?
Liability insurance. So that if it bites anyone, they're covered.
How much do you usually expect?
$100,000.
Liability, see, I didn't know.
And service dogs get unemployment.
They can apply for CPA. They'll get a certificate.
They get free rent.
And service dogs don't tend to, they're not gonna be running around.
Yeah, exactly.
But I get so many applications that say, but he's a service dog. And everybody has a service dog today, everybody.
So we as a realtor, probably, when we advertise a listing, we should put some of these requirements.
You wanna be really careful. You don't wanna get sued.
Anything out there, we just wait for the.
Yeah,
application.
I'd wait for the application.
Yeah.
Yeah, and that's a really good
And
point.
then ask for.
I always say, come in and fill out an application. I've got 10 kids and, 3 pit bulls. Can I come to your property? Come in and fill out an application. Because you got people who are shopping to sue you. I'm Section 8. Can I come live in your community? Come in and fill out an application. This is a real story. I was not involved in it from the beginning. They said over the phone, how many people can live in your 2-bedroom apartment? They said 2 adults and 2 children. They got sued. Why? Because children under 2 don't count as a person, and they had 3 children. They had no intention of moving to this apartment. They were in North Jersey, they bought another house. They just wanted to show that their rent in North Jersey was say $2,000 a month. South Jersey was $1,000 a month. They would have saved $1,000 a month, and they wanted that difference in rent.
What?
Someone calls in and says, I'm on Section 8. Can I come and move into your apartment? Never say no, just say come in and fill out an application. Now, can we do a credit background check for Section 8? Yes, we can. Because they're still normally paying something.
Can you refuse them on their credit? Section
Yes, you can.
7?
Yes, you can. Now, that was something else I was gonna discuss if I had time.
On our NTN report, there's a section for it. If they are Section 8, you have to click on it, which runs a different parameter for them
Bad credit, we should turn them down.
What was that word?
I'm sorry. If you have bad credit, we should turn them down. I knew there was something else I wanted to say. All right. Criminal background checks for my depressed person. Hi. Starting February 1st,
Of
22. We're all screwed. You have to, in New Jersey, this is New Jersey law. You can't turn people down basically for criminal background unless they're horrible. So you have to first, and this is part of the package. First, you have to run a screening and not look at their criminal background. So be really strict on credit. Do not let someone with bad credit in. Treat everyone the same. Be really strict on credit. Then, once you preliminarily accepted them, then you can run a criminal background check. Now, there's certain criminal activity that you can turn them down for no matter what. Automatic fail, murder, aggravated sexual assault, kidnapping, arson, human trafficking. Okay, you don't have to let them in. But pretty much everything else, you do. So, and I'll give you this example because it happened to me. This guy threatened me and a judge. And he said, I know where you live, I know where you work, I know you have a daughter. And he called me a Jew bastard and said Hitler should have burned me. And this went on for months. I finally got him evicted. And I thought I wasn't allowed to file criminal charges until the case was over. So what'd they do? They downgraded it to an ordinance violation. Is that something you can exclude, misdemeanor or an ordinance violation? Recent case, a recent thing, it doesn't matter. He can still move into your apartment. However,
Because they do that.
well, I'm going to tell you the other side of it, but I don't really believe it. However, he has an eviction during COVID, and it was an eviction for cause. So he's popped up everywhere, no one will give him housing. And he threatened the judge. So he did no contact order. Very recently, of course, he contacted me and said that me and the judge should be shot and he hopes we die. So anyway, is that going to be criminal and excluded? No. You can't turn him down for that. All right, so the moral of the story is be very strict on credit. And I give you an example. Be very strict on credit. Don't let someone come in with a cosigner because their credit's so bad. Because if you accept them the cosigner, now you find out this guy was bad, drug selling, if you're selling drugs, they downgrade it. They downgrade everything. So now you can't keep them out. So what's the other side to that? There is another side. People have a right to housing after, they have a right to redemption. We do believe in that. So, but the thing is, this world is so draconian. So if someone went to jail, they served their time. We don't want them on the street never finding housing. On the other hand, we don't want them in our community if they're beating up their neighbors. And if you're beating up your neighbors, that's not enough to keep you out. Because what's that downgraded to? Harassment. And
I'm sorry, so that, use an example, that guy in Mount Laurel who did all the racist things that was on the news. So he gets out of jail,
What
you have
was
to ignore that?
what was he found guilty of?
Twins.
Verbal harassment or whatever, he was harassing that neighbor and Saxony.
Harassment is not an excludable offense.
Yeah,
It was racial and it was.
They're saying he's still at the right zone.
Well, hopefully it's bad credit. But here's the problem, and this is the big problem.
They usually do a bit.
You just accept the really good person. You've accepted a wonderful husband and wife. They move into your community and you've accepted them. Now their kid gets out of jail and he moves in. What do? Can you do anything?
They're not on the lease.
Doesn't matter. What's your approval process? Can you deny someone who's, not met this criteria? They're gonna be able to bring in their criminal children. I mean, right now I keep the criminal children out. On the other hand, it's gonna keep me really busy. Because those criminal children come and they start stealing and causing all kinds of problems in the community.
Selling drugs on the sidewalk.
So
Yeah.
then the kids were not in the lease, so you can keep them out?
No, because let's say you have 2 bedrooms and you got 2 people on the lease. Now they bring someone else in. That person has to be approved. What's your approval process? You have to, if you discriminate by saying it's a 2-bedroom place, you can only have 2 people in, you've now violated housing.
But do they need to be added to the lease?
No, they can be added as occupants.
Okay, they're added.
But once they're added as occupants, you might as well add them. I mean, they're still tenants. You can call them whatever you want.
Is there an age that, like, when you say a kid gets out of jail?
I just met a kid. It
I
doesn't-
know, but like, mom would take in her son when he gets out of jail.
He's 30 years old.
Right,
Doesn't matter.
doesn't matter. She could take.
As
him
long
in.
as she has the bedrooms, she doesn't matter.
She could take him in.
She can take him in and there's nothing you can do about it because people who are criminals have a right to live somewhere.
Mhm.
And
they
it's
can
gonna be
bring-
bad.
And Lori, they can bring anybody, like if my clients bring friends to live with them?
Can you evict them if they get arrested while they're in the?
Depends on what they did. Did they get arrested in the community or outside? So if, someone goes outside and grabs a little girl and rapes her, well, they didn't do it in your community, so no. But hopefully they'll be thrown out. So these are the things. Yeah. Is the person depressed yet?
Those rental properties sound great.
Ronnie did have a question. She asked,
Profit shares
what is
will be
considered bad credit?
Well,
Good
it
question,
depends,
Bonnie.
it depends on the community. I think 650 for an apartment, 600 for a mobile home park. But it's what you establish, but you have to treat everyone the same. I mean, how many times have I run into, and I tell this story, oh, they seem like such nice people. I have a friend, they're the nicest people in the world. He's a psychiatrist, she's a medical tech. They have 2 kids, they're wonderful, sweet people, way nicer than me. You'd run to them in a heartbeat. Their credit score is 425. They've destroyed every apartment house they've ever been in. They have 4 dogs, 2 cats, 13 snakes. And they have literally destroyed every property. So, you can't judge a book by its cover. You really have to treat everyone the same. I have a civil rights complaint, it's like, this is crazy. So the guy's like, he's quote unquote disabled. And he says that he was turned down for this housing because he was disabled. So here's the backstory. He was evicted from this place for not paying rent. Said, I can't afford the rent. Moves to another place that I represent, doesn't pay rent there either. And now he's trying to come back to the same place he didn't pay rent in and moved back in, and he still owes them a balance. He says, the only reason they're turning me down is because I'm disabled. Like, no, we're turning you down because you didn't pay us and you broke our lease. We don't have to let you back in. But I've got so many civil rights complaints, was like the silliest things. You've got to treat everyone the same. Like one guy, my client turned him down. There were 5 of them, they were all on disability. He turned them down. They filed a civil rights complaint and said they were turned down because they were dark-skinned white people. He said, I'm Lebanese. What do you think I am? But they're all looking, they're looking to sue you for turning them down. You gotta be careful.
So I have a question on that. If you get an application and the credit score is a 675, the income's satisfactory to meet the rent. And you're about to go to lease with them and you get another offer. Now this awesome tenant comes in and 775 credit score, making more money. Can you refuse the guy who's good and go with the guy who's great?
Well, have you already accepted the first person? Until you enter into a lease.
Right.
Once you enter into a lease, no.
No, not the,
You haven't
they're
entered
still
into-
looking at applications.
Doesn't the lease have a 3-day attorney review as well?
No, generally they don't.
So you're still just looking at this
Agreements of
tenant,
sale do, but leases don't have.
but
to.
now you're declining him because you like this guy
You can
better.
do that.
That's
Yeah,
not
you can do that.
discriminating?
No, as long as it's not for an improper reason. Credit's not improper. Credit has no color.
Yeah, but this, I'm saying like, you don't know what they are, but they have a 675 credit score that's decent, but a 700 comes in.
What do you think's happening out there?
No, I guess it is.
That's exactly what's happening
I'm
out
just
there.
asking because I don't want to be,
As long as you're
cross the
basing
line.
it on credit alone
Credit and
I
income.
mean,
and income.
So you're saying this is a better qualified tenant
Yeah,
And
That's
you're
why
turning
people-
down a good qualified tenant for a better one, that's
Yeah,
okay.
it's fine,
Okay.
it's fine. And
Because
keep
we
your,
tend to just take like the first good qualified tenant, even if somebody's second or third, just not to take the chance of having someone say, hey.
you don't have to do that. You can take the best person. I mean, Ocean
Okay.
City, there were 30 people that came for this one apartment.
Mhm.
You know, they took the best one.
Yeah,
Of course they will. You know,
okay,
they want the person who's got a job.
yeah, well, they
And
all
who's,
have.
no, I'm just saying that, you know, you can do that. You can take your best person. You
Okay.
just can't use an improper criteria.
Right.
And if your criteria is credit alone, it's fine.
Okay, so credit is king.
So after you have reviewed after you've accepted your 775 person, and you find out that they have a major criminal background, then you have to send them a letter in English and Spanish telling them why you're turning them down. Now, the rules for all of this are going to be coming out. I don't have the updated rules, they haven't come out yet. But this is going to, and the letters that you have to send the tenants telling them why they're being turned down. But this is kind of like check the box. So you're not allowed to ask new employees before you hire someone on your application for your job. You can't say, do you have a criminal background? You're not going to be able to say, do you have a criminal background on your application for tenancy either. You're going to have to take that out. And then once the person comes in, then you can do the background check and say, hey, there's a problem. We had that in my own office. My husband and my daughter were so excited. There's this woman, she was great, bookkeeper from Philly. She was a fantastic experience. And while they were talking to her, couldn't have done it before that. I said, why is she here? And I found out theft by deception. So after the person comes in, you can do background and criminal check, but you can't do it while they're there. But the real issue is, what do? I can't tell you how many times people bring in their aide to help them, and that aide is a heroin dealer. And they're helping them by making money through the community, selling drugs. And there's nothing you're gonna be able to do about that, but you will be able to get them for selling drugs in the community, yes.
So Lori, at least my process for screening tenants is I do an NTN report.
And Han's gonna change its report and take out the criminal background, because you're not allowed to see that until after you preliminarily accepted them.
Okay.
So
Now,
Like a second step.
it's a second step,
now.
and they're gonna be able to sue you if you turn them down.
Now.
Oh, wait, there's one good piece of news for the depressed person. The piece of news is you as landlords are protected from being sued by the people who you brought in the other residents. So you bring in your drug dealer or whoever, the other people can't sue you.
So that kind of needs income. So you're good.
This one is Lori.
Sorry.
So do I always have to tell them why my client rejected them?
So you send a letter on the credit, you just send your typical credit, ask the credit bureau why you're accepted, why you're denied. They give you that letter. Once it gets to be criminal, you have to tell them why. And you just pray for bad credit.
And now if,
I would
do I
do,
always have to be honest with? Like if my landlord doesn't want them because they pets, like.
That's.
Yeah.
you can turn people down for pets. It's not an improper reason to turn people down.
Okay.
There's so many people
I
looking
just
for
found
housing.
that to
It gets
go-
back to Gina's question. There's so many people looking for housing. I'm gonna pick the person without the pets. The older couple who are gonna possibly have children. And then you can't do that. And pick the people without the pets with the good income over the person who's got like 5 pit bulls. But they lie. They all come in and say, I don't have any pets. And then they have them. The problem is, if you want to turn someone down for criminal, you gotta be really careful, because you can get sued, because it's not even just that. You then have to look at the age of the offense, how much time has elapsed, what have they done to, make themselves better? Like the guy who went after me, well, he went into the mental institute, he apologized, he went for, I don't know, Holocaust training, I don't know if he did. But, can you turn him down for that? So that's gonna be a problem going forward.
A
Maybe we can-
lot of reports that I see that have criminal records, some of these records are like 10 and 12 years old. And a lot of it was like, like when they were very young, or they didn't pay child support or whatever it was, or it was a
Use common,
restraining order.
use common sense. I mean,
Yeah.
there was this one attorney who's like, no, total criminal denial. Well, you know what? Some kid smoked pot when he was 17 or 18 or whatever. Come on. But-
The age.
But like my favorite story, is the guy, he was disabled, he was a paraplegic. And he said, he was selling drugs through the mobile home. And he had 20 email addresses that were, I got pot for you at Yahoo, at Hotmail.
Right.
So his attorney's like, well, he's a paraplegic because he was in a, DUI or not, driving under the influence and was in a terrible accident. He was like, well, he can't do anything because he's a paraplegic. I was like, well, he's selling drugs. Because we wouldn't accept him as a tenant because he was recently selling drugs. I don't know if I could do that today, but he had 20 email addresses. So I introduced the email addresses to the judge, who just couldn't stop laughing. And I said, look, he's still doing it. And I bring on the tenant and the neighbor, I'm hoping she's going to testify. And instead, she starts talking about how he's bringing women in and they're laying on top of him and it's just what they're doing. It's like, no, I wanted you to talk about drugs, honey. And it just didn't, the judge got it because we had 20 email addresses and the judge said, well, you're lucky I'm a criminal judge. This guy's not a casual user, he's a dealer. So, and that was recent. But what if it was a couple of years ago? Could we keep him out? And what do most drugs do? They downgrade it. So you look at the age, clearly, it's like, we all make mistakes when we're younger. We don't want to never have housing because of that. And that's the concept. The concept is that we don't want people on the streets, living on the streets. We want to give them a chance to move forward. On the other hand, we don't want the child molester or, the kiddie porn guy in your community, or kiddie porn woman, sorry, or kiddie porn person. We don't want them in your community. So are you going to be able to keep them out? Probably not. We're probably going to have to evict them unless they've done something so serious so recently. But most of the time, these people have terrible credit. I've always said for 30 years, turn them down for credit. If someone has questionable credit, don't make an exception. Not in this market, you don't have to. There's a ton of people out there with good credit who are looking for housing. All right, I don't have anything else to say, nor when I'm running at the end of my voice, as you can hear. Does anyone have any questions?
Quick question.
Sure.
So in a circumstance where you would be living in like a condo and the HOA doesn't allow pets,
Yes.
or the situation that
HOA cannot exclude service animals and emotional support animals. They
so,
get sued for that.
okay. So if you have an emotional support animal, or if you want one, and let's just say you have diabetes, for example, technically the housing can't prevent you from bringing that.
As long as you have a doctor's note linking it. So an emotional support animal is not going to help diabetes, but a service animal, there are service animals that will, they're amazing. Like if you had epilepsy or if you had, diabetes, they know when your sugar's too high. And they go and they do something about it. I don't know what they do, but they're really good. So, but an emotional support animal, let's say someone has PTSD, they came out of their, they were in the military and they have PTSD. An emotional support animal will help them. Now I have an interesting civil rights claim. The tenant says that they have PTSD and that they can't be around noise. And it's a family mobile home park. And they don't like their neighbor's woofer. And they filed a civil rights complaint because the landlord wasn't restricting the neighbor playing music. And I said, I'm treading the dangerous ground here, I'm really sorry, but this is what I did. I said, this guy's white, right? What's the color of the guy next door who he doesn't like his music? I want to put that in the response. The guy next door was black. And the white guy didn't like the black guy's music and was filing a civil rights complaint against my client because they wouldn't stop the guy from playing his music. How do you like that one? And then there was a guy 2 doors down who was Hispanic. He didn't like his music either. Like, okay, maybe you should move into this community. We can't stop people from playing music. And That's what people are doing, they're crazy. Everyone's home, they don't have anything else to do but complain. So we have to respond to all of this.
So it's the verbiage of saying it's a service animal, not an emotional support animal in the circumstance that I just.
Yes, that would be a service animal, but emotional support animals and service animals have the same protection. The only difference is, so they don't have to pay fees, they don't have to pay certain monthly fees, they don't have to pay, there's no deposit on them. The only difference is that on an emotional support animal, you can ask way more questions. You can say, show me the proof, show me your doctor's note, show me this, show me that. The people come with the fake internet service animal in their little vest, no. But it's kind of like, we know when it's a real service animal. The only thing you're allowed to ask for service animals, what is it trained for? And then who trained it? And if they say, I trained it. Yes,
Is there a maximum amount you can charge for a pet fee? Because I've seen them range, and some of them I find horrific, but
no,
legally. they
but
can
you
charge
can't
for
charge a
one.
pet fee for a service or emotional support animal. So then everyone's animal becomes an emotional support animal. So no, you can't. There's no maximum. The courts kind of get pissed when you do.
Well, yeah, like someone tried to charge like $75, it's like a month, and I was like, I think that's ridiculous.
It is, the court won't like that. It's just like late fees. Is there a maximum you can charge for late fees? No, but the court doesn't like it when it's above 10%. Is there a maximum that you can increase rent if they're not under rent control? No, but it can't be unconscionable. What's unconscionable? I don't know. I'm seeing 40-50% rent increases
Right now.
right now. Is that
But
unconscionable?
10% usually.
10% goes. Yeah, 10% is a rule of thumb, 10% max on late fees. It's just really hard. The higher you make your pet fee, the more likely that animal becomes an emotional support animal. My daughter is very stressed at high school. She needs this animal to help her deal with all the Facebook comments about it. It's a game they play. So, maybe just raise your rent to cover the fact that these people have these animals. So that was the other question. If I come in with an animal, I'm not allowed to charge them a pet fee. Can I charge them a higher rent? Interesting question, isn't it?
I've seen it.
Yeah, I suggested that to my landlord in Pennsylvania because we couldn't charge a fee, so I suggested to just add to the rent.
Yeah. Just charge it. This is your rent.
$40 more for the pet.
Yep, you just charge them higher amount for rent. You just don't say it's for the pet.
Oh, you don't put that in the lease?
No, if you put that in the lease, then that animal becomes an emotional support dog. They don't have to pay it anymore.
Right.
For an emotion. I had two
So
cases.
just make your offer, make your best offer.
I had 2 cases in a week with, I'm not joking, potbelly pigs that were over 200 pounds. They were emotional support ones. One was a service, one was emotional support. Yeah, pigs, oink, oink.
What service?
I didn't.
They make ham and cheese sandwiches.
They kept the people from having ham and cheese sandwiches. There was no bacon, no ham,
Not long.
no pork products.
That was a month ago. All right. Yeah.
Application versus the criminal background check.
Yes.
So say you have 2 applicants that are similar credit, not the greatest, like maybe around 650, but you do your own research and you find out that one of them is on the sex offender list.
Sex offender, is it permanent sex offender or just sex offender?
I don't know, you tell me.
Well, if it's, first of all, if you've got it through Megan's Law, you can't turn them down, so don't look at the Megan's Law website ever. But sex offender, you can turn them down, but the problem is you don't want to turn them down. You want to say, look, we found another tenant.
Okay.
You don't ever want to say, I'm turning you down because of your sex offender status. I found another tenant. That's what most people
And you don't have
say.
to give a reason why you chose another tenant.
I had a bunch of tenants, I picked someone
Yeah,
else.
Okay.
And this is
Less
also.
is best, yeah.
This is also, sometimes I've had a couple cases like this where the guy was 25, girl was 15. And they're married, they've had kids together, but the parents were pissed that they were having sex, and the guy's on the sex offender list. Should he be punished forever for that? She was probably more mature than him. You know, I mean, I've had that case a couple times, and it's sad. They should never not have housing. So you have to like look at the facts and circumstances.
So question to reverse that, how was that with the mortgage company?
As far as,
Sex offenders, when you approve their,
we don't do a criminal background check. Only if you want to work at the mortgage company.
Not to lend them money.
And we do criminal background checks in my accounting and law firm, so. The more criminal activity you have, the better you are. Anybody have any other questions?
got more experience.
You understand the system? Okay.
No pot smokers in your rentals.
Unless they are medical,
But you can require them,
They can get edibles.
no, edibles or vapes. I mean, I'm having a lot of issues with people with the stink of marijuana. Not that this is part of the conversation. I have no sense of smell, but for 6 months I could smell. And I was at a concert with my husband. I was like, what is that? I said, Gloria, that's pot. I was like, oh, it's horrible. I never knew. So, I mean, I can understand why you wouldn't want pot being smelled, you know, with kids around. And I do believe that secondhand marijuana is a problem. But you can require, and you should look at your leases, people to smoke a vape or an edible, eat an edible, or do something that's not spewing the smoke into the air. All right?
That is awesome. Thank you.
Any
Any
very much.
questions from the Zoom people?
Thank you so much.
Emily, Alana, Ronnie, any questions, guys?
Always informative.
Okay,
Thank
I should
you.
get credit for coming
Well, I guess
here.
you're like-
Yes,
Shot.
CE credits.
thank you very much, I hope you feel better.
Yeah.
I don't feel bad. That's what's the worst part of this. The worse I sound, the better I'm
All the
getting.
same.
It's like, whoa, I'm better, but this happens like twice a year. Yeah, it's allergies. And it's like, oh, you're welcome. Okay. And I normally sound a lot better than this, right?
Right. And we can hear you.
Well, you could hear me, couldn't you?
Yeah.
Oh, no, I mean, in the office, we can always hear you.
And my son's like, "You doing this in person? Good luck with that. Thanks. All right, thank you all.
Thank you.
Thank
Good
you.
afternoon.
Thank you.
You're welcome. And you all.
Parts behind